Welcome to This Explainer. Today, we're diving deep into the highly complex, incredibly high-stakes world of California child custody cases. Specifically, we're going to unpack the immense and frankly often misunderstood power of court-appointed professionals. If you or someone you know is navigating the family court system, getting a grip on the hidden mechanics at play here is absolutely vital.
So, I want you to ask yourself this critical question. Who is actually deciding your child's future? We usually think the judge is the sole decision maker, right? But while judges absolutely make the final legal rulings, it is very often third-party appointees who conduct the investigations, write the reports, and truly steer the fate of your family behind the scenes.
Here is our roadmap for today. First, decoding California court appointees. Second, systemic bias and absolute immunity. Third, Pickey's Law, the 2026 reforms. Fourth, establishing cause for removal. And finally, number 5, the Elkins cross-examination mandate.
Let's jump right into Section 1, Decoding California Court Appointees.
A massive trap for laypersons in court is conflating minors' counsel with a guardian ad litem, or GAL. Using the wrong terminology here can completely derail your legal strategy from day one. You see, while minors' counsel acts as a traditional legal advocate, specifically bound to present the child's actual expressed wishes to the court, a guardian ad litem serves a completely different function. A guardian ad litem is actually an agent of the court, governed by the Code of Civil Procedure Section 372. Their job isn't to advocate for what the child necessarily wants. Instead, they act as a surrogate decision-maker. They conduct these sweeping investigations to report on what they believe is in the overall best interest of the child. So why do they get appointed in the first place? Well, a GAL isn't standard in your typical divorce. Bringing one in is a massive escalation, usually triggered by severe complexities. We're talking about things like profound parental substance abuse, debilitating mental illness, really complex move-away disputes, or high-conflict abuse allegations. And when they are appointed, a massive amount of control over the litigation narrative transfers directly away from the parents and over to this third party.
Moving on to Section 2. Systemic bias and absolute immunity.
Navigating this system often feels incredibly unfair and rigid to protective parents, and honestly, there are structural reasons why. For years, advocacy groups like the Center for Judicial Excellence have compiled some truly harrowing data. They've revealed a severe disconnect between the clinical realities of domestic abuse and the built-in biases of court professionals. Historically, protective parents' warnings were just completely dismissed. This led to tragic, catastrophic outcomes during court-ordered visits and even resulted in children being forced into these highly controversial, completely unregulated reunification camps that use therapeutic coercion. Now, this lack of accountability boils down to a shocking reality that most people simply don't know about, a legal doctrine called quasi-judicial immunity. Because GALs perform functions that are intimately related to the judicial process, appellate courts grant them an absolute shield from civil tort lawsuits.
The 2013 case of McClintock v. West confirmed exactly this. Now, the policy rationale behind this makes sense on paper. If a GAL could be subjected to financially ruinous lawsuits by angry parents, well, no qualified professional would ever take the job, or they might be coerced into favoring highly litigious parents. But this precedent is a chilling reality for litigants. It literally means you cannot simply sue a GAL for negligence or bias. Your only viable remedies lie strictly within the procedural confines of the family court itself.
Which brings us to Section 3, Pickey's Law, the 2026 reforms. Thankfully, in direct response to public outcry over these exact systemic biases, a profound legislative shift took place. 5. That was the age of a little boy named Pickey. He was tragically murdered by his father during a court-ordered, unsupervised visit, a visit that was granted despite his mother's desperate warnings about the father's abusive history. His heartbreaking loss sparked the sweeping reforms of California Senate Bill 331, which we now officially call Pickey's Law. Pickey's Law legally restructured family courts with two absolutely massive changes. First, it explicitly dictates that child safety must definitively supersede default presumptions of equal, shared parenting time when abuse allegations are present. And second, it completely bans the state from ordering children into those unregulated, multi-day therapeutic reunification camps that force them into isolation from a preferred parent. This was a real game changer. Furthermore, the law mandates rigorous, ongoing, trauma-informed training for all GALs and evaluators. They are now required to be specifically trained to recognize coercive control and to truly understand the long-term impacts of trauma.
It specifically tears down the old, incredibly flawed heuristic that domestic violence only occurs if there's a formal restraining order or a substantiated CPS finding.
All right, Section 4, establishing cause for removal.
So let's talk tactics. How do you actually use the law to challenge a biased appointee? Since we already established you cannot sue them for damages. Well, you do have the right to file a formal motion for removal under the California Rules of Court. But you have to prove good cause. And I need to be super clear here. This is an exceptionally high evidentiary bar. Mere disagreement with a GAL's recommendations or just being frustrated with their demeanor is entirely insufficient.
To successfully remove a GAL, you have to present substantive, documented evidence of severe ethical breaches. We are looking at things like undisclosed conflicts of interest, for example, serving as both a child's treating therapist and their evaluator. It also includes exceeding statutory authority, like making unilateral medical or psychiatric decisions without a clear court order, or a demonstrable failure to investigate objectively. Think of a scenario where they totally ignore critical collateral witnesses, like your child's teachers, but they exclusively interview your ex's relatives. If you can meticulously document concrete procedural violations like these, you can actually build a solid factual basis to get them removed.
Finally, let's look at Section 5, the Elkins cross-examination mandate. But what happens if your motion to remove the GAL fails, and you are forced to go to trial against a report you know is biased? Enter the Elkins mandate. Established by the landmark 2007 California Supreme Court decision, Elkins v. Superior Court, this mandate is your absolute strongest tool. It protects your constitutional due process right to present live testimony and to cross-examine a court-appointed evaluator. You are not just quietly defeated by a hearsay paper report, you have the right to systematically dismantle the appointee's findings right there on the witness stand.
Let's break down some advanced strategies you can use under this mandate. First up, subpoena their raw notes and their full investigative file, not just the polished final report they handed to the judge. Second, demand methodological transparency. Ask them point-blank why they ignored certain pieces of evidence. And third, and this is highly effective right now, question the GAL under oath about their compliance with the new Peaky's Law training updates. If they cannot articulate the nuances of coercive control on the stand, their competency is immediately compromised. Let's visualize how this builds in a real courtroom scenario. Imagine asking this exact question on cross-examination. This specific methodology strips away the expert's aura of infallibility. Notice how it doesn't rely on angry emotion. Instead, it relies entirely on exposing the structural fragility, the bias, and the overall incompleteness of the investigator's logic.
The ultimate takeaway from this whole explainer is that while the family court system undoubtedly grants third-party appointees immense power and robust immunity, it also provides you with sharp, highly specific statutory weapons to enforce accountability. Knowing the law completely transforms you from a helpless participant reacting to a report into an empowered, strategic advocate for your child's true best interests.
We hope this structured breakdown empowers you to face the California family court system with renewed clarity and strategic confidence. Remember to document absolutely everything. Lean hard on the structural requirements of Peaky's Law, and never, ever forget your right to cross-examination. Armed with the Elkins mandate and Peaky's Law, are you ready to hold the system accountable? Stay informed and keep advocating for the truth.